Hi, everybody. My name is Adam Rossen from the Rossen Law Firm, and I'm so excited to be doing this CLE regarding Florida gun law and firearms law with you folks. We're going to have some information about us at the end of each slide. So, reach out, okay? Because we do these things because we really want to help our fellow attorneys. We've had so many attorneys in the past and continue to help us as well. And this is just really important to me and everybody on my firm that we give back to the profession. So what we're going to be talking about is a bunch of different, facets on Florida gun law. My presentation is going to focus mainly on the new law changes that came about last year, which allows now constitutional carry. So we'll talk about all those things. Then we're going to have Krista Richmond and Susan Lawson from my firm as well discuss other areas of Florida gun law. So first, let me go ahead and let me tell you a little bit about Rossen Law Firm, just so you know who we are, okay? We are based in South Florida. We handle state court criminal cases, all types of state court criminal cases in South Florida, so really Upper Keys through North Palm Beach County. And we have a separate federal practice where we handle cases nationwide regarding healthcare and white collar crimes. So this is us. Our firm's motto is when we help good people when bad things happen. Susan and Krista are both on the right. They'll introduce themselves, of course, but Susan is a board certified criminal trial lawyer. There's about 400 in the state, and Krista is well on her way to becoming board certified as well. So really cool stuff that's going on here with us. Now, who am I? Okay, so this is me, a little bit about me. I don't like to talk too much about me, but this is me. I'm the owner and CEO and founder of the Rossen Law Firm. We have some different bios and stuff. So, you guys can obviously take a look at that. And now let's get right into it. Okay, so my portion is going to be the carry concealed firearms or the concealed weapons, the law changes that went into effect last year, that went into effect last July. It was a big sweeping change in Florida, and the prosecutors are still figuring it out, the police are still figuring it out, some defense attorneys are still figuring it out, but it's so important and it's been such a fundamental change that I really wanted to start this CLE off with this discussion. Now, understand, I'm gonna have a lot of statutes on these slides. I usually don't like putting a ton of information on these slides, but sometimes it will be a little dry, it will be a little boring. There's going to be a lot of the statute and the words on this. Doesn't make for the most fun and engaging presentation. I promise I will do my best to make this fun and engaging for everybody, but it's really important that I wanted to put all the statutes and all the subsections here so we can really go through piece by piece by piece, okay? So what law was amended? It was Florida Statute 790.01 and a few others, but this is where we're going to go to start. It's the carry concealed weapons and concealed firearms. Now, subsection 1, the law change is saying that a person is authorized to carry a concealed weapon or firearm if they're licensed, so you can still get your concealed weapons permit. Okay, so there's a lot of nuances. So the Florida legislature did not do away with the ability to maintain, to renew a Florida concealed weapons permit. So you can still go that route if you so choose. But it's now 1B, which is or if you're not licensed but otherwise satisfy the criteria of receiving and maintaining such a license under the statute that provides how you can get a license. So what they've basically done is removed the requirement to formally jump through the hoops, to formally pay the money to the Department of Agriculture, which is Florida Department of Agriculture, which is the government agency that manages the concealed weapons permit. So they said, look, you can go through this process, pay this money if you want, but now you don't have to pay this money if you don't want, but you still must satisfy the certain criteria that we've said you need to do in order to carry a concealed firearm. So this is not the full wild, wild west. I will talk later about open carry. Open carry is still illegal in Florida. This is commonly referred to as constitutional carry, okay? But this does not mean that everybody can carry concealed without a permit. That's also very important. And a lot of what you see on people's websites and on the news articles, or when you watch the news shows about this, they got it wrong, or they gave a little snippet. So that's why we're doing this. So now, section 2. If you don't meet the above criteria, okay, and you have a concealed weapon, the penalty is a first-degree misdemeanor. That's the same as it was before. Okay, carry a concealed weapon was always, well, not always, but for the past many years, it was a first-degree misdemeanor. It is still a first-degree misdemeanor. And if you don't meet the criteria and you illegally carried a concealed firearm, the penalty is a third-degree felony, what we call CCF, carry a concealed firearm, that crime. That was the law before. That's still the law. So it's still a crime. There is still a penalty. Section 4 or subsection 4 is very important. Now, what this did, it's kind of similar to what the Florida legislature did with requiring the prosecutors, as part of their burden of proof, to disprove self-defense when self-defense is alleged under Florida standard ground law. Okay, so now what they're doing is, if there's a violation of carry concealed weapon misdemeanor or carry concealed firearm felony, the state now has the burden, as one of the elements of the offense, to disprove that to say that the person is not licensed to carry and that they're ineligible to receive and maintain the license. So now it is significantly harder for the prosecution in a trial on these type of cases to prove that somebody was ineligible. It can still be done. It just requires a lot more work. And we'll go into, right, of course, why is somebody now going to be ineligible to either get the permit or to, receive and maintain the permit. Okay, so it's, that key number 4 as well, because police officers still make arrests for this. Prosecutors still try to prosecute for this, for these crimes. So it's really good. You have to know and really push them. If you are a criminal defense practitioner, push them to prove ineligibility. Okay. Now, as far as the next slide, let's discuss 1B. Okay, so if we go back a section, right, here's 1. I don't know if you folks can see my cursor, but at the top there's 1, and then there's 1B, and 1B references somebody who's not licensed but otherwise satisfies the criteria to get the license. Okay, so here it is. This is 1B. All right, and maintaining such license, and it goes into 790.06, and it's 2A through F, I through N, subsection 3 and 10. So it's a lot of different things. So in the next few slides, this is going to be the part where it's a little dry, where it's listing out all of the different ways that somebody would be ineligible to get the Florida concealed weapons permit. But we need to know these things. And the good thing is, if you knew these things before, they really haven't changed. There's a few little minor tweaks, but they really haven't changed. So there's a lot of text here, okay? All right, so the Department of Agriculture and Consumer Services, they're the licensing board. Okay, they shall basically issue a license. Now, we talked about resident of the United States, and it says citizen or permanent resident. Okay, you have to be 21 or older, and we have the does not or has not been. So you can't have a physical infirmity which prevents the safe handling of weapons. Okay, if you're a convicted felon, you still cannot, possess firearms or ammunition. Okay, so by that logic as well, you cannot have a concealed weapons permit. Now, if you've been found guilty of a crime, and this is the exact same, so of a drug crime, okay, drugs are Chapter 893, or similar laws of other states, to any controlled substance within a 3-year period immediately preceding the date on which the application is submitted. So obviously it wouldn't necessarily be the application submitted date anymore. If you're not trying to get an application, it would be the date that you carried, or if you were arrested, it would be the date of arrest. Okay, and that's been the same. If you've been Marchman acted, so Chapter 397 of Florida statutes. That's the Marchment Act law. Marchment Act is a very obscure Florida law. There's only a handful of attorneys that I know of that handle Marchment Acts, but it's a very good law. And what a Marchment Act is you would have a family member or caretaker petition the court. It's basically a Baker Act for drugs. So as we know in Florida, and we'll talk about, the Baker Act is for mental health. The Marchment Act is getting a court to order somebody involuntarily, okay, against their will, to go to residential treatment because they have a drug issue, an alcohol issue, and it's a very niched, nuanced law. But the attorneys that do this, they do great work, and they're helping tons of people. So if you've been committed for that, then obviously they don't want you, to be handling firearms in any capacity. Okay, if you've obviously, if there's disabilities, okay, or or deemed not to be committed for the abuse of a controlled substance. So there's a lot more to this. If you're chronically or habitually use alcohol to the extent that your normal faculties were impaired. So that's kind of a catch-all. It's a little vague, but what they're using this is to define that if you've been deemed to be, a habitual offender through habitual disorderly intoxication. What I went ahead and did is a lot of the statutes that they cited, I just put what it is in parentheses to make it easier, so that way you folks are not having to do the whack-a-mole or deep dive into, okay, well, they referenced eight different statutes. What's this statute? What's that statute? So if you've, 856.011 subsection 3 is the habitual disorderly intoxication statute. If you've had 2 or more DUI convictions, so chapter 316.193 is DUI. Now that is within a 3-year period immediately preceding, okay, the date of the application, or if you didn't have the application, then it would be the date of possession. So, if you had 2 DUIs 20 years ago, well, that in itself wouldn't be a disqualifier, okay? They're really talking about the presumption of 2 convictions within 3 years, immediately 3 years before, okay? If there's any guardianship based on incapacity. A lot of the Marchment Act and the Baker Act attorneys, they will also try to file guardianship petitions to allow your family members, or the clients, or the individual's family members, to make decisions for them. So if there was a Marchment Act or a Baker Act, and then there was a subsequent guardianship, or even if there was never a Marchment Act or a Baker Act and just guardianship based on incapacity, you cannot handle firearms. Okay. Subsection J is the Baker Act. Okay, have not been committed to a mental institution under the Florida Baker Act. K is you have not been adjudicated of had adjudication of guilt withheld. So this is important too. Okay, if you've had any felony, whether it's drugs, alcohol, anything, it doesn't matter. It doesn't have to be. It's any felony. And you've received a withhold of adjudication. That does not make you a convicted felon if you've never been adjudicated guilty. Okay, for some cases and some people, getting a withhold of adjudication on a felony could be a fantastic result. However, if you receive a withhold and it has not been 3 years since probation or any other court conditions have been fulfilled, then you cannot have a concealed firearm. So, for example, let's say there is a criminal case and you plead guilty to a withhold of adjudication and 3 years probation, and the probation is not early terminated. Then when that probation period is done, let's say you serve the full 3 years, then you have to wait an additional 3 years, okay, upon that. So it could be quite a while until you are allowed to possess a firearm, okay, or the record has been expunged. Now this says expunged. If you received a withhold of adjudication, you would not be eligible for an expungement. That would be eligible for seal. We may get a question. Well, I'll just proactively answer the question. What about a seal? That's a good question. That I don't know the answer, so we have to do a little more research into that to see if a seal is going to have the same effect as an expungement, which I could see them saying, well, hey, we didn't put seal in here, we specifically excluded it. However, having a record expunged, if you have a record expunged, you would never be eligible to do that if you received a withhold of adjudication. An expungement would be if the charges were dropped. A seal would be for specific crimes that receive a withhold. So there's a little gap in that in the law that actually we should probably do some more research on for you folks. Okay. And M is have not been issued an injunction that's currently in force and effect and restricts the applicant from committing acts of domestic violence or acts of repeat violence. So this does not talk about, this part does not talk about injunctions against stalking. It only specifies domestic violence or acts of repeat violence. And if you're not prohibited from purchasing or possessing a firearm, I skipped ahead. By any other provision of Florida or federal law. So, of course, I think where most people would get tripped up is if there's some kind of issue with federal law, because that's I think the way they did this statute was a pretty all-encompassing version to include Florida law. Now, the journey continues. Okay, so what's Section 3? Okay. Again, a little dry stuff, but it's really important. And these slides will be available. This is definitely something that you should save these slides. You should have this as a resource because, again, there's so many little nuances for this. Okay. This is saying the Department of Agriculture will deny a license if you've had adjudication of guilt withheld or any imposition of sentence suspended for one or more crimes of violence constituting a misdemeanor unless 3 years have elapsed. Okay. So now, and on this one, it says unless it's been sealed or expunged. Okay. So this one mentions seal and expungement. Now, as far as Section 10, they talk about how it can be if you have a current license, how it can be suspended or revoked. So, which is if you've been found to be ineligible based on, so let's say, for example, you get your concealed weapons permit, last year, 2023, you're good. You have it for a few years. It's still eligible. And then you get Baker acted and then you get Marchman acted. Well, then you would be ineligible. And, if the Department of Agriculture does their job and finds this out, then they would suspend you. They don't always, but most of the time they do. I think they're actually pretty good about this. And that's what Section A says. Of course, and this is really repeating a lot of the same things. So if you've been found ineligible, if you have a physical infirmity, right, if you develop or sustain a physical infirmity later, if you're convicted of a felony, okay, if you're found guilty of 893, it's Marchman Act, it's second DUI, it's incapacitated under a guardianship, it's Baker Act, it's really all the same things, and they're just covering their bases. Florida laws, they're covering their bases with this because, of course, you could be eligible today, you could get the permit if you so choose, and then tomorrow something else can change where you would be ineligible. Now, they did specify here ways that you cannot violate the statute. So, of course, if it's lawful self-defense, if it's self-defense, if you're using self-defense chemical spray, and these are basically the same as what it was before, but of course, I think it's good for us to discuss that as well. A non-lethal stun gun or dart-firing stun gun or other non-electric weapon or device that's designed solely for defensive purposes. Okay, so the stun guns that we have, where they fire the dart, right? Or you can do the drive stun, which is actually the contact tase. Okay, as long as it's designed solely for defensive purposes, then you don't need a concealed weapons permit. You can't violate the statute. And actually, you've never needed a concealed, well, I don't know about never, but since I've been practicing law, you have not needed a concealed weapons permit for a device that's solely for defensive purposes. So that could be pepper spray, right? It could be mace. It could be something like that that is solely the legislature has said those are solely used for defensive purposes. But if you're using a non-lethal stun gun during the commission of a crime, then yes, you can still be prosecuted for that. Okay, and so that's also a very important distinction. So now, right, okay, well, what are some rules, in order to legally carry a concealed weapon without a license, right? How do we go about and actually make sure that we're not unintentionally violating the law? Because as we discuss this, you know, being in possession of a concealed firearm illegally, it's a if you go back to criminal law class, it's a mala prohibitum crime. It's not a malum se crime. It's not a Ten Commandment or a morally wrong crime. This is a regulatory crime. Possessing a firearm when you're not supposed to is not a crime of violence. It's a crime of regulation. Okay, so that's something that especially a lot of young prosecutors and police, sometimes they misunderstand, and they immediately just hear the word gun, see a gun, and you immediately think violence. But no, this is a regulatory crime. So of course it's important that people understand what the rules and regulations are, and are on notice, so that way we don't violate them. Everybody knows murder, right? Not something you should do. Rape, robbery, burglary. But again, this is a regulatory crime, so we need to know, how to comply. So this is going to be held in Chapter 7, or Florida Statute 790.013, which rules for legally carrying a concealed weapon without a license. So now they're changing, they've changed some of this. So you have to carry a valid ID at times when in possession of the concealed weapon or firearm, and you must display on demand. So that makes sense, because now, before you had to have your concealed weapons permit, which was a photo ID, which had all of your information there. So if you don't need to have the photo ID or the actual permit, you still have to have some kind of valid ID. And of course it says valid, so it can't be an expired driver's license or an expired passport. It has to be valid, legally issued ID and show it. The good news is, if you don't have it on you, it's a non-criminal violation. It's a $25 fine. It's it's a traffic ticket without, being on the rules of the road. So, without being on the road. So it's similar to a traffic ticket. It's just a very minor thing that require, that is a fine. Right? But of course, also from a legal perspective, you don't, you want to carry it. You want to have an ID with you at all times. So one big thing now that we're seeing is, well, what do we do with non-residents? There's a big topic of reciprocity among the different states with their concealed weapons laws. There's some states, especially some of the Northeast states, that don't have much reciprocity with any other state. I know New York, right? New York is very tough on their guns. And generally speaking, in the South, especially Florida and Texas, we're a little more liberal with our guns. So what happens, right? We are one of the tourism capitals of the country. If you're a non-resident and you're here, right? What, do our firearms laws, or especially the new ones, do they apply to you? So you can, if you're not a Florida resident, you can carry a concealed firearm if you are a resident of the United States, if you're 21 years or older, and if you satisfy the criteria of being here. Okay, so they've basically said, hey, come on vacation, come here, and our laws will automatically apply to you, so long as if you were a Florida resident, they would apply to you as well. Okay, so and Section D is saying that now they're giving reciprocity to everybody. Okay, so Florida has opened it up where they now have reciprocity. So if you have a valid concealed weapons permit with in any other state, you automatically have reciprocity here for a limited time. Okay, and so Section 1 is really more about short-term stays. If you're vacationing, if you're traveling here, if you're, let's say you're going to, Disney World. Obviously, you don't want to bring a firearm to Disney World. That's a whole separate topic. Okay, but if you're coming down here, if you're traveling, whether it's by plane, by car, by boat and you're a US resident, you're 21 or older, you satisfy the criteria if you were here, okay, if you lived here, or if you have a valid concealed weapons or firearm license in another state, automatically eligible, automatic reciprocity. Section 2. Okay. So non-residents who move here. So if you're moving here, right, and obviously you have an intention to be a resident here, then you're automatically good for 90 days. So that's also important to note. Okay, you're valid for 90 days after establishing the legal state residency. The problem is a lot of people don't establish legal residency. So some people there, or we have people who are, well, I'm here for 6 months and I'm in New York for 6 months, or I'm in, Texas for 6 months and here. So what they're saying is, as far as establishing legal residency for this, it's registering to vote, making a statement of domicile, or filing for homestead tax exemptions on property in Florida. So one of those three criteria under the law says that counts as valid legal residency in order to immediately get the benefits of possessing a firearm in a concealed manner. Okay. Now this is a this is a big one as well. Open carry, and what we've seen two different issues arise with people, with our clients in the last year and a half, who have misunderstood the law. The first is open carry, which we're going to talk about now. The second one is thinking that anybody, even if you're a convicted felon now, you can carry concealed. Okay. So we're going to talk about open carry right now. That's 790.053, still illegal in Florida. Okay. We have not moved to Texas yet or to some of those other states. Now, there is an exception, and the exception is to briefly and openly display the firearm to the ordinary sight of another person, unless it's intentionally displayed in an angry or threatening manner that's not in self-defense. So you can bring your firearm out in public to show somebody if it's briefly and openly displayed, like, hey, look at my gun. Isn't this a nice, cool gun? Right? But you can't show it. You can't threaten somebody with it. You can't have it maybe concealed in your waistband. Lift up your shirt if this is going to be in an angry or threatening manner. That's not necessary for self-defense. So that would still be a crime. That would still fall, most likely it could be multiple crimes. There could be aggravated assault of a firearm, potentially in those circumstances. And then they could hit you with a carry concealed firearm, charge as well. So it's good to understand that. And as we talked about, the manner in which some of our clients are still making mistakes with this, yes, it's open carry, and it is situations that I discussed earlier regarding mistakenly believing, oh, great, my cousin's uncle's brother's sister told, I don't even know if that makes sense in the family tree, but somebody, my buddy told me at the family barbecue that we had 3 weeks ago that now everybody can carry a concealed weapon and you don't need a permit anymore. Well, that's just simply not true. If you're a convicted felon, if you've been Baker acted, Marchman acted, had 2 DUIs, or whatever, or fall under any of those. And of course, as we know, most of our clients, they're not reading the full law. It's what they heard, what somebody told them. It's what they saw on the news that gave a brief snippet. So as attorneys, it's incumbent upon us, especially the ones that practice criminal law, to let our clients know, hey, wait a minute, there's been a rule change, but this rule change is probably not what you think it is. And again, when we're talking about a crime that is a regulatory crime, it's very important to know that most of this is good-natured, innocent thinking conduct that is just via a violation of some of the rules that we've made in order to try and have a safe functioning society. So as far as the lecture on this topic goes, this is what I have for you. It's I feel like when you break it down like this, it's pretty easy. It's just you have to strip through a few layers at a time. We have a QR code to stay in touch, but what I'm going to do is I'm also going to take some questions that we have from the group and go over those, which is which is really good. Okay, so the first question that we have, are there any state-specific regulations on the possession of prescription medications, including requirements and for maintaining and storing them? So yes, there are. There's tons of state regulations on that. Obviously, doctors and pharmacists have their own regulations as far as how to maintain and store them, but I don't think that's what the question is about. I think the question is more geared towards what normal people like me and you are doing. So you need to have it in the pill bottle. You need to be able to prove that it was lawfully prescribed. What a lot of people do is, from a sense of convenience, a convenience standpoint, they just will take, a few of their medications, controlled and not, right? Narcotics, ones that are potential for abuse and others, and just put them all together. So a lot of people will say, well, maybe, I'm a man and I don't have a big giant purse. So I'm just going to take one pill bottle and I'm going to put my Xanax and I'm going to mix it with my blood pressure medication and my allergy prescription medication because they're all different shapes and sizes. And I know what the difference is between them. Well, that's a major no-no. Okay. You can't do that because if you get stopped and you encounter a police officer, how is the police officer going to know that that's lawfully prescribed instead of being bought from a friend on the black market, whatever it is, right? And they're not going to know. And in the heat of the moment, they're not going to care to find out. Okay? And that's the bottom line. So if that situation was to arise, do criminal lawyers beat those charges later? Well, yes, all the time, especially obviously if you have a valid prescription. Okay. But the point is don't put yourself in that position. We always advise our clients to keep it in the pill bottle. You must. Well, what if I'm traveling and right, can I get a smaller pill bottle or something? Well, some pharmacies, if you contact them and talk to them, they can give you, a smaller pill bottle or a travel pill bottle. You just have to talk to the pharmacy. Okay. We've had some clients have success with that. Or look, it's just something at the end of the day, what's a bigger inconvenience? Taking a few of your medications together, maybe putting them, in a backpack or, in a big purse, right? Obviously, for whatever is easy to carry, maybe a little knapsack or, a little, shoulder strap or something, shoulder bag, or going to jail for a felony, right? For a day or two, bonding out, paying an attorney, and we get it dismissed. Fantastic. But how much money did that cost you? Shame and embarrassment of having your mugshot on the internet, being arrested, being put in handcuffs, spending a night or two in jail. I mean, that's terrifying for a lot of people. That's very scary. And then it's still public record, even if the case gets dismissed. And then you have to go through a whole nother process to expunge that record. And what we tell people is, well, what if you're 45 years old and you had a DUI when you were 23 and you were convicted of that DUI when you were 23? Guess what? Now you're not even eligible to expunge this felony controlled substance that was dismissed within a month, right? You're not even eligible, so it'll be on your record forever. And could that hurt you for a job? Yes. Could it hurt you for, you know, a rental property or housing come up on a background check? Yes. Right. Could your nosy neighbor do some searches and find you? Yes. So it's all things that are it's very embarrassing that we don't want. Next question is, how does Florida regulate the possession of handguns, including any restriction on carry, concealed, or open carry? So I think we discussed, that as far as, I think, we discussed that through the presentation. So if I didn't, just let me know and we can talk a little bit more, but I'm pretty sure that we went ahead and did that. What are the possession limits for alcohol and tobacco products in Florida? And are there any special regulations for minors? So, well, tobacco is 18. alcohol's 21. Um, as far as when we're talking about limits, as far as the amount you can buy, not to my knowledge, if I know plenty of people that have very impressive alcohol collections, who are, over 21, especially of certain, fine wine or alcohol. Obviously, there's a lot of restrictions on who can sell. Okay, that's highly regulated. But as far as just possession, as long as you're over age, as long as when we're talking about alcohol, you can't have an open container in the car. And of course, if you're driving impaired under alcohol, chemical, or controlled substances, which tobacco or nicotine is not one of them, then that would be or could be a DUI. You could get arrested for DUI. And of course, that's a whole nother lecture. We have lectured on that. Actually, we have a lecture from about 2 or 3 years ago through My Law CLE. So I would say go ahead if you need your CLE credits for that as well and want to learn all the ins and the outs of DUI law. You can definitely go ahead and view that. We had a great time filming that about 2 or 3 years ago. It was a lot of fun. Um, and really for tobacco, it's just for minors and reselling. Um, and obviously if you're over 20, if you're over 18, you can't sell it to minors, you can't buy it for minors, you can't do anything like that. But, to have nicotine in your system is not a DUI by any means. So really, as far as those things go. Now, the full deep dive of specifics regarding alcohol and tobacco and those government regulations, especially like in a reselling setting, whether it's at a store, at a bar, or restaurant, that's beyond my scope of knowledge. So as a criminal defense attorney, that I don't know. How does Florida enforce regulations related to the sale and use of prescription drugs, and what are the penalties for non-compliance? So those are things that's another great question. That's also beyond the scope of my knowledge as a criminal defense attorney. Um, as far as we're talking about, pharmacists and doctors and what they can prescribe. Um, as far as the medical marijuana, clinics that have all come up. And of course, this year, if you're watching this, people could be watching this at a lot of times. We're filming this in September of 2024. So it's been about a little over a year since the gun law change, but we are having another amendment on our ballot in November to potentially make Florida go from medicinal marijuana to recreation marijuana. So of course, all of those regulations could change as well, but that is not my area of expertise. We got, this is a great question actually. So let's go, let me go ahead and ask this question. So how do the recent amendments to Florida's firearms statutes impact the defense strategies for attorneys handling firearm related charges? So that's a really good question. So there's always a difference between the legal strategies and more of the practical strategies. So some of the practical strategies is we want to make this as much of a pain in the butt on overwhelmed, overworked, and underpaid prosecutors as we can. Okay, so that's important. Now, what do I mean by that? Well, when we get these cases now, there's, what we've found is the prosecutors, especially in South Florida, in Palm Beach, in Broward, in Miami, they're a lot busier than the prosecutors in some of the smaller, sleepier, more country areas of Florida. So when these prosecutors are worried about prosecuting robberies and drug traffickings and violent crimes and victim crimes, when you get something like this, that again, not a violent crime by nature, by definition, not it's a regulatory crime, and now part of their burden of proof is disproving the presumption that the person was allowed to carry the firearms. Then this is significantly harder for the prosecutors to prove. Okay, so it's more work. And when you work for the government, you only have so much time to be a good prosecutor. And this is the same for public defenders. You only have so much time to be excellent at your job on a percentage of your cases. Okay. So naturally, a good prosecutor will have to pick and choose, and they're going to say, well, look, a violent, I'd rather spend my effort and time on this violent crime. So you know what? Maybe we can reduce this to a misdemeanor. Maybe we can, discuss a diversion program. Okay. And some of the counties, I know Miami-Dade, their prosecutor's office, they do have a firearm diversion program. Now, it's there's some pros, there's some cons to it. They tend to be a little restrictive with who they let in. But if they don't, you as a defense attorney, if you can't get a good, quick resolution from the prosecutor that's acceptable to the client, then it's, my opinion and my firm's opinion is always like, hey, great, Miss Prosecutor, we have nothing better to do than to turn this, into a federal case and to litigate it to the ends of the earth. So now we're going to move fast. So let's talk about some legal penalty or some legal strategies. Well, okay, these type of cases, I think, do, if the circumstances are right, lend to pushing it forward aggressively, quickly. To not waiving speedy and holding them under natural speedy, which for felonies is 175 days after the date of the arrest. And it could even be something where, of course, depending on the circumstances and with the client's consent, that you might want to file a 50-day demand for speedy. Okay, so that's another issue that may come up because now, the prosecutors might be scrambling. They're going to have to try to get this stuff, put into requests from all the government agencies and really do a lot of work that the police should have done. And we found, the squeaky wheel gets the oil. A lot of times, the more times we make them work and we make them work hard, it's like, look, you really want to do all this because your time is going to go away from the serious cases. And either we get a good result at the absolute last minute by pushing it ready for trial, or the prosecutors just come back fairly quickly and say, fine, just let's do we can even do an informal diversion. Or here's a misdemeanor to, maybe a reduced charge, something else, and let's just, be done with it. Okay. And obviously the decision to, if that's acceptable or not is always one that you have, with your client. And I believe, clients need to have full informed consent, and understanding of how everything's going to affect them before a decision is ever made with that. So, look, we do take depots if it's the right type of case to take depots on. We'll absolutely take depositions. We'll absolutely still explore it with a motion to suppress, with a motion to dismiss, and again, put pressure on the prosecutors. So, you really can go both ways with that, but we've also found that by pushing this forward hard, and even in the pre-file phase too, because in South Florida, the vast majority of the case filers are not the ones that are going to be trying the cases. And they're under their own internal time deadlines. They're getting a flood of cases that they have to, file on roughly within 21 to 33 or up to 40 days. And they don't want to have to go through with, again, getting these documents and trying to set it up. So if you can really hit them early too, we've had fantastic results with that as well. Okay. Now, as far as the lawful possession of firearms under Florida law and how these rules intersect with federal regulations, that's a great question. I think in order to answer that, that's a little bit beyond the scope of what I have prepared today, because that's just a whole, another issue. But really, the federal regulations are primarily designed, and what we see in federal court, it's more about the application to purchase firearms. They're really looking for people who are blatantly lying on the federal firearms, applications, people who are buying, those firearms. And so the feds are really looking at that, and they're leaving it up to the states to decide as far as the concealed versus open carry, and how, right, and how much the states can really, come up. Really, it's more, I think the current state, the status of it is they're letting the states decide, to what degree the states can really restrict people. Okay, and obviously there's been some U.S. Supreme Court cases now coming out that have been very, the Bruin case, that have been very friendly to gun rights, to the Second Amendment, with just the makeup and nature of the court. Um, and in response, especially the southern states have really loosened up a lot of the firearms laws, and the northern states have been having cases, have been people fighting against some of their restrictive laws, and they've had in those individual states, the people that have been pushing forward in the federal court and the federal appellate system have had generally very good success. Um, Now, we have another question about risk protection orders. So, risk protection orders are going to be covered by Susan. She is extremely knowledgeable on risk protection orders. We defend against those. Florida created, just to give you some background, and I know Susan's going to go into it anyway, but after the shooting at Marjorie Stoneman Douglas, the Florida legislature very quickly passed the risk protection order. I believe the law was passed with the best intentions, but I do believe the law is overbroad. I believe it's overly restrictive, and I personally believe it's unconstitutional. Susan will go into all those details. But we have seen from a criminal defense perspective, which she'll also talk about, is the police now, they have their or the individual cities, the cities that have their own police departments, they have one of their city attorneys who's a big portion of their job is dealing with risk protection orders, making them get served quickly, efficiently, and really trying to go through very fast, so people get these temporaries and then get these placed on them on a year, for a year, and then they're trying to even extend and renew them, and they're being very aggressive with enforcement on it. And I understand good intentions, but I think they're being personally too aggressive on it. And we've been fighting against these with some good success in our firm. So that's something, and Susan will go into great detail about that. Next question was, what are the most significant recent legislative changes affecting firearm possession and concealed carry permits in Florida, and how should attorneys adjust their approach to advising clients accordingly? So again, I think it's really, this is what we covered here with the concealed carry. I think we as attorneys have duties to inform our clients and former clients about changes in the law every year, every 2 years, as they change. Now, is this a legal duty? No, it's not. But is this a moral duty? Is this an ethical, really, right? It's a moral duty, okay? And so there's a lot of, especially in criminal defense, solo lawyers that are so overwhelmed, and they're just trying to keep up and handle their cases and get new business, and not really run their firm like a business. So they're doing everything. They're answering the phone, or maybe they have one trusty sidekick, and they don't have time to stay in touch with their own clients. They don't have time to maintain a list. Some of them don't even have time to be updated on the new law changes. So obviously we're doing that here for everybody listening to this CLE webinar. But I think it's incumbent upon us as lawyers, and especially all types of lawyers, but especially criminal defense lawyers, because we're talking about people's futures, freedoms, and their families' futures and freedoms, to make sure that we're always staying in touch with our former clients, that we're providing value to them, that we are community and relationship builders, and that when these law changes happen, that it's incumbent upon us to post about them on our website, to send a newsletter to our list, to send an e-blast or multiple e-blasts to people when we're talking to clients, former clients, to let them know, hey guys, look, you probably have heard about this, but let me tell you what it really is, because we don't want our clients to get rearrested. At least we shouldn't. Okay, we don't. And, again, especially for a regulatory crime, because that's all that this is. So I'm a firm believer, and, especially everything that we do at the Rossen Law Firm, we have a big social media presence. We have, a list of, I don't know, right now, maybe it's up to about 3,000 people on our list that we email, maybe 4,000 that we email, multiple times a month. We give them law and update changes, and the laws usually as we know, go into effect, July 1 or October 1. There's always some other, things that kind of pop up. And also as case law changes, right? It's not just if the legislature passes a new law, it's if there's a major case law, major case update and the case law changes. And, again, it's not a legal obligation, but I think it's really a moral obligation. So that's a great question. And that's why you need to know these things. So again, I want everybody to have these slides. You can print all these things up. You can, if you really want, you can condense some of these into maybe a 1-pager or 2-pager and send them out to your list and your people. And you can even host your own webinar for your clients, your family, your friends, your referral sources, and just say, guys, come, let me teach everybody. You may get 10 people. You may get 200, but even if you get 10, you're paying it forward, and that could be 10 other people that you've prevented to unnecessarily get arrested for a very serious felony, which again could have long-lasting effects. So that's a great question. Again, I hope that I gave you folks value on these law changes. If anybody has any questions, wants to stay in touch, here's my QR code. For the firm, it's Rossen Law Firm. All 6 attorneys in the firm, we do different CLEs. You'll be seeing us quite often with my CLE. We've done things in the past, and we just, we want to have fun. We want to educate. We want to pay it forward in our profession. So please reach out at any time.